release for David Messenger, filed by Attorney Michael Devlin, pursuant to Connecticut General Statute, Section 17A 588, continued from June 27, 2008, at the request of counsel. I have a two-page document marked PSRB Exhibit 1 with today's date, which lists all the materials that will be considered as evidence for today's proceeding.
Thank you. Attorney Gaeta, I understand that your client has chosen not to appear at this hearing. Is that correct?
That is correct.
We will proceed with you here but without his presence.
That is correct. Just a matter of business first. We've had some communications over the last couple of days regarding a continuance. The first communication was denied. I had then asked you and the board to reconsider, listing several different factors, I think 9 different factors regarding that. You had then denied that as well, without specifically mentioning the factors, just denying it outright. I would like to renew that today as I'm here to make that request as a part of the record, as a preliminary matter.
Well, I take it then you have no intention of presenting any evidence at this hearing today.
That is right. For the reasons that are stated in the letter, the continuance is necessary for the issues that are relevant to the conditional release application.
Well, I've decided we're going to go ahead. We will give you the opportunity to present whatever evidence you feel you need to at a subsequent hearing. And once we conclude the proceedings today, we will probably continue the matter to a later date for you to present whatever it is you wish to present.
Well, as you were aware, Mr. Messenger, of course, and Mr. Coleman, who submitted the application and wrote the application, are not here, and it is his application. I think appropriate procedure would dictate that Mr. Messenger begin the presentation of evidence, and then after he was done, of course, should any evidence on the other side be presented, and then we would have an opportunity to rebut that. I think this procedure does not accord the rights as specified in the statute, and so I would object to that procedure, and again renew my request to go forward. Number one, and number two, object to procedure of this unorthodox fashion of proceeding.
Your objection is no to counsel, but we're going to proceed anyhow. We went back, we've been down the street. This is the second time. We attempted to hold a hearing once before. It had to continue at the request of counsel, either your co-counsel or previous counsel.
Attorney Devlin is still counsel of record. We are co-counsel, I guess you could say.
Well, he had requested a continuance before, and we granted that. We've scheduled this hearing specifically at his request. The victim is here and is going to make her victim impact statement. The hospital is here and will make a statement concerning the plan that you have that has been presented. So we will proceed with that. We will give you an opportunity and your clients to make whatever presentations you feel you need to at a subsequent hearing. We will not make our decision based solely on what's presented today, because we will give you the opportunity to make presentations. I think that is reasonable and fair in accordance with the statute.
Well, again, you noted my objection to that proceeding. We certainly took pains to ensure that no one or no parties came here unnecessarily, and there were communications with the State's Attorney's Office on that regard by Attorney Devlin and myself to some extent, but more with Attorney Devlin. I mean, anticipating that there may have been problems with the presentation of evidence today. Certainly, there doesn't seem to be any prejudice to anyone but Mr. Messenger with going forward today on that regard.
Well, I can't imagine Mr. Messenger is going to be prejudiced. We're just simply going to take a statement from the victim, which would be allowable under any circumstance. And it's really more of an impact statement than anything else. You will have an opportunity to hear it. You can address it in subsequent hearings if you desire. We're going to hear from the hospital as to what their feelings are concerning the conditional release plan that has been filed, which will give you an opportunity to understand what their objections are. Perhaps you can address those when you make your final presentation. representation for the subsequent hearing.
We've been provided with the hospital's position in their report to the board, so we understand that position. Again, I think that going in this fashion is somewhat prejudicial to Mr. Messenger, as it is his application that we are here. And there are some issues, as I stated to you in my letters of the last several days, that prevent us from following standard procedure in this case. And again, the hospital is privy to what's happening with Mr. Messenger. There seems to be no prejudice on their part. You know, they work 300 yards away. Again, I renew that request and seek an answer as to who's prejudiced other than Mr. Messenger proceeding in this fashion.
Again, I will indicate to you, as I have in the two previous letters that I wrote, that we will deny your request for continuance.
The board is aware.
At this time, that is not to say that when we hear from the victim and when we hear from the hospital, since your presentation is not ready at this time, we will not conclude the hearing. We will continue the hearing so you will have an opportunity to present whatever evidence it is you wish to concerning the application for the conditional release.
Well,
We've scheduled this hearing and we are going to go ahead with it at this time.
well, the board is aware, and it seems to be that it's a very adamant position, but however, the board is aware, as is evidenced by the statement on top of the agenda, is that the agenda is subject to change up to and including the day of the hearing. So this is not really anything that's, nor is this request anything that is out of the ordinary, so to speak. However, the proceeding in this fashion, I believe, is out of the ordinary. So when you balance all of the interests involved and the rights and the statutory structure and all that, I think that it weighs inside in favor of Mr. Messenger to have a continuance granted. Certainly, the fact that a continuance was granted in June is not dispositive of the issue of whether one should be granted today.
Counselor, I've listened to your objections, I've noted them. We will note them for the record. We are going to proceed.
Well, then, in that, if the board is stuck on that position and will not articulate any further the reasons that I put forth in the letter of the 10th of September, I believe I put 9 different reasons why a continuance should be granted. And if those will not be addressed any further, and that is your position, then we're going to withdraw the application.
Are you indicating you're withdrawing the application for conditional release at this time?
That's correct.
Do you intend to resubmit it?
That remains to be seen. I don't know that needs to be answered now, nor is that answer contingent upon whether the application should be withdrawn or not.
Well, you certainly have the right to withdraw your application. It's yours, your client's application.
Given the stance that has been taken, that's the position that we're forced into.
Fine, we will consider the application withdrawn at this point. And no further necessity to proceed with anything on this hearing.
Okay.
The hearing on the matter of David Messenger is hereby adjourned because the applicant has withdrawn his application for conditional release. Thank you all for attending. Good day.
Thank you.
I would rather not run it. Make for a leader, why not? Okay.
Sensitive.